Hi, everyone, and welcome to the ICAMEK podcast. It's such a great honor to be here today. And today we are hosting a very, very special and honorable Justice of the Court. Before I introduce him, I will introduce myself as your host. My name is Asmahaney, Saad. I'm an advocate practicing in Uganda, a partner at KT Advocates, also an ADR practitioner, and I'm happy to be able to host this podcast. Today we have Justice Geoffrey W.M. Kiryabwire, and briefly, he is a judicial officer with 22 years of experience in the judiciary of Uganda. He currently serves as a justice of the Court of Appeal and Constitutional Court of Uganda, and also a court administrator of this court. He's the former vice president of the East African Court of Justice in Arusha, Tanzania. Before being appointed to the Court of Appeal and Constitutional Court, he served as a High Court judge and is the former head of High Court Commercial Division. He's, of course, done so many things. He's been part of so many spaces, innovation, the bench, and I'm happy to also note that he's an OB from Makerere University. So that's always good when you... In terms of innovation, Justice Kiryabwire introduced new innovation and practices like the introduction of the small claims procedure in Uganda, the appointment of the first court-accredited mediators while he was at the commercial court, the introduction of the scheduling memorandum and trial bundle before hearings, the procurement and the launch of ICAMEK. For those who have interacted with this system, you know this is the Electronic Court Case and Management Information System, the development of a judgment writing tool right now in its validation stage. So it goes without wonder or that even in our alternative dispute resolution space, Justice Kiryabwire has innovated and also kept as one of the biggest advocates for ADR in so many ways. I'm so honored to be the one to host you today. My Lord, you're welcome.
Thank you for having me.
Thank you for being here. We know it's such a busy, not so busy, of course, you're taking a rest. I hope it's restful. It's a restful holiday now that courts are on holiday. Or is it business as usual?
I wish. There is no reprieve for the justices, really.
So it's business as usual?
It's busy.
Of course, before we start, I try to ask around because, you know, the biggest practice group we have now are the young lawyers. But when I try to ask the few sample space I did, I found that most of them know about you. And I think one of the reasons, like I was sharing, you're one of the few judges who has a website. Very innovative. And
Probably.
Yes, and we've interacted with so many of your judgments. I think that connection has also kept people in purview of who you are, no matter the age group. Today we just wanted to speak about mediation, but with a lens of mediation in arbitration.
Yes.
Perhaps to start us off is to just give us a foundational role of arbitration.
Well, there's not terribly that much difference between arbitration and litigation. The main difference between the two is one is driven through the state, through the courts, and arbitration is private. So if you want, you can say that litigation is private justice, while arbitration is private justice. The state will cover the cost of the justices, cover the cost of the courts, and even though you pay for fees and things like that, there's a very big input from the state. Whereas arbitration is purely private. The arbitrator is paid for, all the facilities are paid for, and so from that point of view, there is a difference in alternatives. Do you want to have private justice or do you want to have public justice? So that's the first difference. The second difference is that the rules are fundamentally different. The rules in litigation are fairly structured. There are a lot of rules of how you can or cannot proceed.
True.
So the rules of evidence, the rules of procedure are very structured. In arbitration, they are not. Because it's private justice, you decide your script. So for example, you may operate in such a manner that you may not give a lot of weight, for example, to the hearsay rule. You may have all kinds of alternatives in terms of procedure. You can have, for example, in arbitration, an arbitration on paper only, in which case nobody is going to appear before the what? The arbitrator. On litigation, on the other hand, it is very uncomfortable if you don't see the judge. At some point, you want to see the neutral. Because in arbitration, it is private justice. You have your sketchboard. You can decide how your image will look like. And you all undertake to abide by the result of what you have decided. In litigation, you must abide the structures that are in the rules, that are in the procedures, that are in the law, what is also in the case law. So that is the difference. The result, however, is pretty much the same. In litigation, you must have a winner and you must have a loser. In arbitration, it is the same. It is almost impossible to perceive a draw. The other thing that allows arbitration to be of interest to certain types of people is that in litigation, the courts are structured in such a way that if you're not happy with the lower court decision, you can appeal. You can go to the next level, you can go to the next level, as the rules would permit. Depends what your entry level was. Was it a trial, first appeal, second appeal, third appeal? You have those options. In arbitration, it is viewed as final, and you will not have a structure where you can have an appeal. Even though now, in some jurisdictions, they are creating some form of appeal from a decision of an arbitral tribunal. But it is very rare, and it is not extremely widely used. Even when you hear people saying, I am appealing a decision of an arbitrator, it is not actually an appeal. Actually, what is happening is you're seeing the arbitration award being tested in the court.
Yes.
To see that it is in compliance with what the people said the arbitration process should be. So there are limited areas of review which can happen in arbitration. The idea why it's an alternative is people are given the options to determine how quickly do they want the dispute to be resolved. With arbitration, you can have time control, which is very different from litigation.
Yes.
Litigation, you enter the queue. In arbitration, because it is private, the concept of a queue is far more limited. Indeed, if it is an institutional arbitration, you may even find that you don't have a queue. You select who your arbitrator is going to be. So normally these institutions have lists, so you pick. So I want this one and this one. This one's not available, okay, you bring me that one. Whereas in litigation, they say you're stuck with Kiryabwire, unless there's reason for me to recuse myself, you're stuck with me. And it will depend on what my docket looks like. So I may give you an early date, I may not give you an early date. So again, it is up to the people who are in dispute to decide, as advised by their legal counsel or advocates or attorneys, as the case may be. The problem that we have seen over the years is there has been a default to public litigation. So if a dispute arises, no matter how small, no matter how big, everybody says, I'm going to sue you. And that means that you're going to what?
Public litigation.
You're going to go to the public domain. And this is, it is a factor of many things, largely training. And even for the smallest thing, the practice in Uganda, if someone is to instruct a lawyer, the lawyer will almost in a knee-jerk manner issue what is called a notice of intention to sue. So the mindset is already crystallized there. Whereas the people who gave us that method of working have changed. They no longer issue, they now issue letters of demand. And in the letter of demand, they will give you a menu of options as to how the dispute can be resolved. But for us, because we have this very strong orientation towards public litigation, that is what happens. So I think those are the alternatives, if you want to call them an alternative, because if the default is to go to public litigation, then that is why arbitration is regarded as an alternative.
Yes.
Which is not the case. They should be at the same level in terms of a decision being taken, whether to go private justice or public justice. But many people default towards public justice. And that's why the reference to the word alternative comes.
That's very insightful. And I think you saying that drives the point and highlights the importance of the parties themselves perhaps being aware. If we draw back, and like you clearly said, that you've highlighted it so well, the people who brought this concept of public litigation found a system that was already working. And in our context, we all know back in the day, before colonialism or all these systems, we all had a system in which people who had disputes knew the best way to resolve them. It was actually more party-led than when the system was structured, so where now you have to come to an advocate and they advise you, which now draws us back to the mediative system. You know, Ubuntu, you know, so many cultures, institutions, families had their own way in which disputes would easily be resolved, and most times led by the disputants themselves. So mediation, we always joke around it, it's now become like the stepsister. The forgotten stepsister of dispute resolution. So litigation and arbitration, it reminds me of that Cinderella story. So mediation is seated there waiting one day to have a chance to be given the glass slipper.
The slipper.
Yet it fits so perfectly. Yeah, so that really brings the whole objective of our discussion today, mediation. It's centered on parties driving resolution of their own disputes.
Yes.
In as much as possible, come out of it, resolve the disputes, and move on with your lives, business, whatever context it is. So maybe to just also drive that into perspective, what do you think is the underlying issue here, even when it comes to arbitration itself?
Well, there's a lot that has been packed into your intro there. And some of it is true, some of it is perception, some of it is not actually true at all. But it is the common narrative, so it can be understood from that point of view. Arbitration has been with us for a long time in Uganda. Arbitration came to Uganda in 1930. So the first Arbitration Act, which largely mirrored the Arbitration Act of England, also of 1930. So we have had arbitration from 1930 up to now, up to the year 2000, when we had the Arbitration and Conciliation Act and the amendments that have come to that as well. Of course, the main difference being that the 1931 also had a lot of limitations in terms of also court interventions, which the 2000 has removed. Because the 2000 now follows what is known as the Ancitro model law. And Ancitro is a different discussion altogether. So arbitration has moved together with litigation, but far less than what 1930 had envisaged in terms of what you can call domestic arbitration. I think if you look at the 1930 Act to 2000 when it was amended, and the post-2000, I think there is a lot more arbitration taking place after 2000 because of the strengths that the ancestral model law brought into arbitration, which really emphasized autonomy, party autonomy, and the most minimal of intervention from the courts. Now, for mediation, mediation by definition arises from a very basic concept that everybody deals with every day, and that is negotiation. People are always negotiating.
Yeah, true.
You know, and I can assure you that many disputes, and I'll come to some detail of that, are resolved through just talking to the other party and saying, you have wronged me, can you make good? And the person will say, okay, let me make good. Then you negotiate an exit from the dispute. Now, sometimes there are circumstances where a bilateral negotiation is difficult, either as a result there's something called the conflict circle, and they are what we call drivers that make it difficult for people to talk. There may be a different value system. There may be issues of emotions. There may be issues of culture. You know, there may be issues of power. You know, all of these drive away the ability to negotiate.
Yes.
There is need, therefore, to introduce an honest broker in the middle of a bilateral situation. So you bring in a third party who is respected by both sides, can act as a neutral, and can help the negotiations to start and get a resolution. That is what mediation is about. Mediation is nothing more than third-party assisted negotiation. So whereas in litigation, the strengths are in what is the law, what are the rules of procedure. The strengths in mediation is what can I give, what can I take.
Yes.
You see, so you want to reach what is called a new state of equilibrium through negotiation. And that's why sometimes it is referred to as a win-win situation. Because the idea is to try as much as possible to re-establish the equilibrium ante the dispute. Whereas in litigation, it is who is right according to the law and who is wrong. And it is sometimes regarded as correct. Sometimes it is seen as unfair. Sometimes it is seen as unequitable. It depends on what the law, what rights does the law give you in such a situation. So, for example, the law may tell you that you can come into the courts, but you must bring, if it's a tort, you must bring it in 3 years. Or if it's a contract, you must bring it in 6 years. But the injury has taken place, and for many reasons, it has not been possible for you to engage. That one will not work in mediation.
No.
Mediation is not time-driven. The earlier, the better.
Yes.
But those considerations are not there. Now, for us, in the Afrocentric dispensation, this is more in consonance with what African traditional justice systems were about. We normally had third-party interveners in our family, in our clans, in our regions, in our tribes. These people would come, if you failed to agree, then they bring in certain factors. Let's say at the family level, either family head. If it was a family dispute, in some cultures you bring in the senga, you know. All of these things were available Or if it was in a particular community, it would be perhaps a special day when people would meet and use that opportunity to resolve a dispute. Actually, in the East African area, this normally used to take place around the market day. You see? So you first come and trade, not really with cash. You do your barter. You want some goats. You want a cow, you have goats. So they say, if you want a cow, give me so many goats. So, all of those things were happening on market day. Then in the cool of the evening, people would go under the mango tree and resolve disputes.
Wow.
And it will be resolved then. That's where the word baraza comes from. You see? You'd hold a what?
Baraza.
A baraza. Now, of course, people then started saying, so now when is market day? So should it be on a Friday? Should it be on a Monday? So we say kubaraza. Then they say, okay, let us start the week with what? With the kubaraza on the market day, on the time when people come.
A lot of activity.
Yeah, when you have a lot of activity. So you actually even can hold what is called a what? A baraza. So these are all indicators that our form of mediation was alive and kicking for 1906.
Wow.
You see? And the system that we're applying, which is the litigation system, only came to our country in Uganda in 1906 via the order in council of UK. So it's just about what, 120 something years old? You see, even my grandfather was alive.
Oh, wow.
You see, even my grandfather was alive. If my grandfather was alive, then this is just yesterday. He was a young man at the time. So the more interesting question is, if we have been having litigation via order in council for about 22 years, why is it an alternative to the baraza system which we have had for centuries? Actually, this is where the conceptual crisis comes in. Because for us, in reception countries, Uganda, Kenya, wherever you're a British colony, the whole purpose of 1906 Order in Council was to degrade our practices. And that's why we even have within it the repugnancy clause. The idea was to downgrade our systems as much as possible and emphasize the new system. Or if you have a dispute, go to court. Now we introduce new stakeholders. We introduce advocates. We introduce bailiffs. We introduce things that we did not have in our own structures. The African traditional justice system actually was self-policing in many ways. Default rate was low.
True. Very true.
But in this one, the default rate is high. But this has been the narrative until a very interesting report for me came in 2016, which is the Hill report of 2016. Now, the Hill report seemed to validate what I had been thinking before, but I did not have a scientific basis for it. And the Hill report said that in Uganda, they went around the whole country, they came out with the figure that only 5% of all disputes that the Ugandan community get engaged in are resolved in the courts. Now, this may appear weird because the courts, as we know, are congested. The courts have backlog. But all of that only equals
to
5%
Wow.
of dispute resolution in Uganda. 95% is resolved outside court, which means, in my view, that the pre-1906 methods are still alive and kicking, regardless of every attempt to destroy them. People are still talking. And I see it all the time. Someone knocks somebody else's car in the traffic and is doing right in front of the traffic policeman. Traffic policeman will come to both of you and say, you negotiate, and goes back.
Yeah, true.
If you fail, you come back to me. And most of the people, that is deterrent enough for them to say, okay, let me take you to my garage and fix your car. Can you imagine if all of those went to court? These are statistics that are not being what? Captured. But that is not only the case. Hill 2016 further stated that of the 5% of people who go to court, only 1% use lawyers. Only 1%. Which means, and this is true, that in spite of the size of the bar, most people don't use lawyers in the adversarial system that is called litigation. And it's only when you come to think about it that you find that it is possible to validate this. Because if you go into a magistrate's grade 3, well, those that are still remaining, I think now they are gone. Now we still have a few grade 2s. And the majority of our courts are G1s. Most lawyers don't practice in G1 courts.
G1,
and yet the bulk of dispute resolution is being done at that level. It's not at the High Court. You see? That's where many people want to go. They want to go to Chief Magistrate, and they want to go to High Court, Court of Appeal, Supreme Court. That's when you see more of the lawyers. You see a much lesser presence of lawyers in G1 courts. People represent themselves. So we start to debunk the thought that litigation is the choice of preference of people who are in dispute. It is not. It is the choice of the lawyers.
It is
not the choice
of the lawyers.
Of the people. It's a choice of the people to negotiate. And it is the choice of the lawyers to go to court.
Wow.
There's no problem with that. That's how we are trained. Now, that is the first thing we need to debunk. Now, Hill 2024, these reports are available on the web. I think they may even be posted on the judiciary website. People can go and look. There's been an improvement to 10% of people now going to the courts. But still, it means that the bulk of dispute resolution is taking place outside the courts. So what does that mean to me? The future of practice cannot be in the 10%.
Yes.
The future of practice must be in the 90%.
90%.
This is an area of low-hanging fruits that people are not looking towards. The training is not looking towards. The attitude is not looking towards. And that is the problem. Now let us take a comparison with the United States of America. In the United States of America, only about 2 to 5% of all criminal cases are tried in a US court system. And trust me, they are very many.
2 to 5%.
Only 2 to 5%. You see the congestion that is in the American courts?
That's just 2 to 5%.
It's only 2 to 5%.
Wow.
The bulk of criminal justice is handled through a process called plea bargaining.
Yes.
And it is handled at the time of plea, time of arraignment, if you want, time of charging. That's why it's called a plea bargain. Yes, we have plea bargain here, but most people who enter our program have already taken plea.
They've already taken plea, or they are in
Yes,
remand,
so they're already on remand.
Yes, on remand.
They're already on remand. So it should be remand plea, remand bargaining.
First go and think about it, then come back and now you bargain.
But in the US, it is at the time of charging, of arraignment.
Okay.
That's when plea bargain happens. And I've had the privilege of being in a US court when this is taking place. It's like a conveyor belt.
Wow.
It is the speed and the efficiency is like a well-oiled engine. The difference in the United States as compared to Uganda is they have a very vibrant office of the public defender, which we don't have. We have a very vibrant ODPP, but it is not countered with a public defense system. The public defense system in the United States is very sophisticated. And anybody picked up and put in cells would have access, not just because it's a felony or a charge that will attract a severe sentence, or murder. Everything is open to plea bargain. Of course, some of the really atrocious crimes, the system will not allow the plea bargain to take root. But the point I'm telling you is that in Uganda it is the reverse. About 2 to perhaps less than 2, perhaps about 2% go for plea bargain and 98 go for trial.
Wow.
Now, one of the questions is, how is it that a poorer country like Uganda
can afford to
do trials when the US cannot?
Cannot.
The same is true for the civil side. And almost every single case that goes into the trials in the US courts ends up in some form of settlement. And I think you read about them.
Yes.
The judgments, even though they appear many, are actually just a handful of what goes through the court system. So what is happening there is they're leveraging on the ability to what? To negotiate. Even huge, environmental cases, oil slicks of billions of shillings, the product liability, the Boeing is going through settlements following the Boeing Max plane crashes, and if all of that was to go into litigation, the amount of money would bankrupt Boeing. So yes, they're in the courts, but they are settling. No, they are settling. They say, let us talk, let us negotiate. In Uganda, we would rather push it to the Supreme Court.
For how many years?
Yeah, for whatever it takes.
10.
We have loan agreements. We have mortgages that have been in the court system for 10 years. A loan has been taken, and it's litigated at the High Court, litigated at the Court of Appeal, litigated at the Supreme Court, and sometimes, yes, the loan is problematic. But I'm yet to see a case from the Supreme Court where they say, don't pay back a loan that you have taken.
Impossible. Because you've taken it.
I'm yet to see that case. So the foundation needs to be that if you have borrowed, pay back.
True.
Now, if there are any issues in between there, then you can take those to court. I mean, if there's a problem with the interest, if there's a problem with whatever. But you can't really go to court and say, I think now we are comfortable. You know, there was a point where the thing was, can you borrow an illegal loan?
Illegal.
You see, it's very innovative,
crafty. Yes.
very innovative way. But you know,
come
most
out.
of us have parents who taught us that when you borrow, you take
You
back.
pay, yes.
Yeah. So I don't know why you need judges to determine these very basic things. So mediation actually has the problem of not being structured.
Yes.
And not only in terms of its practice, but also in terms of the enabling law. And so it is falling under the radar of many practitioners. The good news is that at least Cabinet has now approved the ADR white paper.
Good.
Which means that in perhaps the next parliament, we'll be looking at an ADR Act. And that I don't like that reference to ADR, alternative dispute resolution, because really litigation should be the alternative.
Yes.
But anyway, that's a discussion for another day. It will provide some structure around it. For the judiciary, we have now adopted a policy known as the AJS, the Alternative Justice System. What that is saying is that let us return to the past. There was a movie called Return to the Future. I think we should call it Return to
the Past.
Yes, where we leverage on what has always been in front of our faces.
What has worked.
Yes. And what we want to do is to empower those mechanisms that have always been in our faces, but we have ignored. So we are embarking on training of religious leaders, training of chiefs, training of
lawyers,
even lawyers. But lawyers, let us start. That will go with the ADR. But I'm talking about mechanisms.
Yes.
You know, in the churches, in the mosques. We want that sorted in the families, in the clans. These are the people who have been our shock absorber. If these people, even in the unstructured system, were not working, would not be able to work in the court systems. So we're also, of course, championing training in the law schools. We're championing trainings in Law Development Center. You may not know that now Law Development Center has an ADR curriculum, which is now being mainstreamed, I think, as of last year, into the seminars and workshops that take place at the Law Development Center. So I think we're going to see a systemic shift with time. Where we're going to move from the model of 1906, which is litigation, adversarial litigation. Now I'm talking about the courts.
Yes.
I'm not talking about the 95%. Now I'm focusing on the courts, where Hill has been saying it's been between 5 and 10%. I think that is now going to infect that space. And we're going to move from adversarial litigation, which is the hallmark of what we do, to a process called dispute resolution. I want people to understand that adversarial litigation is only a subset of dispute resolution. It is not an end in itself, which is what has been happening. So we're going to move into what in the US for a long time, from the 1970s, has been referred to as a multi-door courthouse. Because what we're largely having in Uganda today is a single door.
Yes.
Single door courthouse where you walk in and the output is adversarial litigation. Now you'll be able to go into a court with multiple doors. You can do mediation, you can do arbitration, you can do negotiation, you can do conciliation, you can do a lot of other things. As you can do small claims, you can do plea bargaining. You see. So people don't have, the lines should be shorter on the alternative doors than what has been the case for the adversarial litigation. So we need to debunk some of these attitudes and perceptions as well.
Oh yeah, and you have debunked it so well, so well. I really love the concept of the multiple doors, but again, it's driving us towards the public dispute. We are now calling it dispute resolution process.
Yes.
That the parties would still want to be facilitated or
True.
supported by the well-drawn systems, enabling laws, etc., etc. Now, if we draw back to the private dispute resolution,
Yes.
do you see the same evolving, that parties can still be empowered enough?
Oh yes. I think what's going to
that.
happen, especially when the ADR Act comes out, is we're going to structure it.
Okay.
We're going to have it more structured. We're going to create systems, because this is what I think people have been wanting to see. And therefore, I anticipate a significant growth, because I think not everybody will be wanting to go into the public space.
Exactly, yes.
And I think the real lawyer of the future is the negotiator, not the orator. When I came out of Law Development Center, we trained ourselves to submit in court. And the court was very generous to us. They would give us 1 hour to submit, and would talk and would show them that we are orators, we have good English,
and
logical presentation.
Yes.
You know, today the orator goes to the court and we say, adopt your written submissions.
Yes.
So, but say, I want to speak, because there is this thing itching in the body that I have prepared. I've been preparing how to argue.
Yes.
So whatever you can argue, we can read in the submissions. So you go away despondent from the court, because you've not been given your day to speak for 1 hour. There are cases still where we say, yes, we want the orator. But I must say those are reducing.
Yes, yeah.
Those are reducing. Nowadays, written submissions are becoming the order of the day. So the person who's able to write concise and well-reasoned submissions has a better chance of winning his client's case than the orator.
True, very true.
Who goes on and on and on and on and on. So now the skill that the courts are looking for is for good writing. And in some of the rules, we don't have rules yet in the Court of Appeal, but I think the Supreme Court has rules. I think it's 10 pages, double-spaced. No matter how complicated your appeal is in the Supreme Court, you must be able to shrink your ideas into 10 pages.
Wow.
So the person who is able to write and give clarity in 10 pages, or if they allow you leave to add more, is the one who will take the day. Not the one who will speak for 1 hour or 1.5 hours. So the orator is going.
He's going.
The writer is coming in.
He's coming in. The negotiator.
The negotiator is coming in. So the new skills that the young lawyers should be looking for are the ability to negotiate a dispute, not the ability to argue the dispute. I think that is the future. And of course, in my other passion, and this will even move faster than I had anticipated, is the advent of technology.
Exactly. You've prompted my question, but yes, technology, yes.
With the advent of technology, then a much bigger disruption is on its way.
Yes.
a much bigger disruption. So if you are old schooled in adversarial litigation, you feel the brunt of the disruption. And therefore, the negotiator and the person who controls data, the lawyer who has the data, will be in pole position in this race. And the person who argues the case will be out of work, for sure. We're already seeing the advent of AI judges.
Yes, yes.
There's a famous AI lawyer who's operating in Illinois. It's an AI program called Do Not Pay. Do Not Pay is gaining significant inroads into legal practice in court.
Wow.
Actually, the Illinois bar filed a case in court that the program was holding out as an unlicensed attorney and therefore should be restricted. The court ruled against
the bar. Wow.
So we're going to see technology becoming another disruptor in terms of the future that is in front of us. I think in terms of training, the adversarial litigation is going to be disrupted by mediation, arbitration, and things like that. It's also going to be disrupted by technology.
That's very powerful. And I think when you bring in the data, it really, really brings out the reality. With all this in mind, given our context here in Uganda, do you see a time when it reverses and through this empowerment we have 90% of disputes going the other way and perhaps 10 coming to the public system?
Oh yes, because there is evidence of it. Most of the, if you look at the world's leading courts, this has already come to pass. The World Bank for many years has rated Singapore as the number one jurisdiction. And I had the honor and privilege to go to Singapore and see what is happening there. And I can tell you that what we call alternative dispute resolution is coming close to 80% in terms of dispute resolution. The use of technology is so futuristic for a person coming to Uganda, but we are at the same point in time. We're both in 2025 at the same time. But the technological gap is mind-boggling. A Ugandan attorney would be hard-pressed to operate in Singaporean courts. The skill set is so different. So we are seeing this change in Malaysia. It is coming up. I'm not even talking about Canada. I'm not talking about United Kingdom. I'm not talking about the US. And I'm not so familiar. That's another area which I'm going to research in terms of civil law in the continent, France, Germany. I really don't have much information there. But the areas I have been very keen on common law jurisdictions, and I can tell you the flip is in process. If it is not in process here, it is in process in the rest of common law jurisdictions. So that's very important to bear in mind. In terms of training, it is also changing. So it is very important for the universities also to have a deep discussion around this area. Law area grow with lawyers. It will depend how quickly the bar embraces these private systems, because they are so used to the adversarial system and the way of filing bill of costs that come out of that. In fact, one writer was saying that alternative dispute resolution in many jurisdictions is not alternative dispute resolution, ADR, it is acute deficiency in revenue. and
Acute
therefore,
deficiency in revenue.
so that is being flagged as something to fight.
Wow.
But I think every lawyer today,
Yes.
every lawyer today should get a copy of Professor Richard Susskind's book, The End of the Lawyers. And Professor Richard Roskin is a professor of law, I think now retired from Oxford, and is a futuristic professor. And he is looking into the future of legal practice. And he has written this very unnerving book, The End of the Lawyers. And I think he is not saying the lawyers are going to go away. They're saying the old lawyers are going to go away. So the new lawyers, whatever they will be called, are going to take pole position. It's a very interesting book. It's a little bit unnerving given our training, but again, we don't know how. Some people have said Professor Susskind is a fearmonger, or he lacks empirical data for what he's saying. But if you have taken interest, if you're in the innovation space like I have been, you see that there is a lot of wisdom in taking aboard his caution. That if you keep doing the same thing in the same way and expect different results, then I think Einstein said it is not the output that is mad, it is you.
It is you.
If you think that you're going to do things in the same way and expect different results in terms of workload, in adversarial litigation, in terms of backlog, in adversarial litigation, and you're going to claw into the figures for workload, claw into the figures of backlog, then you're going to be in trouble. You're going to have a linear approach to these things. And that's why other people are adopting technology.
Yes.
In China, they now have an algorithm which does sentencing.
Oh, wow.
So sentencing is no longer done by a human being in some of the Chinese states. They've compiled the data. When the trial is done, they just feed the data and the algorithm will say this one 2 years, and this one 3, this one that, this one. Yeah, because how many people in China? Very many.
Oh, billions.
Yeah, so how many people go to court?
Hundreds of millions.
So who's going to sentence all those guys? You know, who's going to sentence all of those people? Yeah?
Makes a lot of sense.
So they're going to leverage in technology. They can't keep on having a sentencing hearing the way we do it to be problematic. I mean, in Uganda, we spend twice the amount of time in adversarial litigation in applications as we spend in main suits. But the result is out of the main suit. Now, if you keep increasing and giving rulings in applications,
when are you going
when are you going to do the main suit? See, we are concluding more applications in the Ugandan judicial system than we are completing suits, appeals, petitions. That is the high turnover area. And if we just continue doing this in the same way all the time and expect backlog to go away, I think there's a problem somewhere.
There is.
And so countries like Tanzania have new rules as far as applications are concerned. Here there's a lot of resistance. I'm the court administrator of the Court of Appeal. I have more requests to fix applications than I have
for the appeals
themselves.
Oh, wow.
And I say, but I thought you want a correction of the decision of the High Court. Why aren't you pushing to fix that date as opposed to fixing the date for stay. There are more applications for stays than there are about nearly times 2.
Wow.
We have about 11 to 12,000 matters, about 4,000 applications.
Just applications.
And that's how it is. Now, of course, the discussion is, should it be done? So discussion has always been around. And I think that experiment was tried and it failed. Should it be the registrars to handle? Or should it be a single judge? Or should it be 3 judges?
Oh, wow.
You see, that has been the jurisprudence, you can tell from what is coming into the courts. Whereas it should be, how can we fast track the appeal? But I think even now recently there has been a decision, I think last week, where that whole discussion went into constitutional petitions. Should it be a single justice? Should it be a panel of 3? Or should it be a full embank of 5? This is the discussion on how do we quickly deal with constitutional petitions, whereas we shouldn't really. I mean, at one stage we were having about 200 pending petitions in the Court of Appeal, which is almost equal to the number of articles in the Constitution itself. So 95 is supposed to be the Constitution where the people of Uganda sat and determined how they should be governed.
Yes.
Different from 67,
Yes.
69, all those, the independence one of 62. Those the people of Uganda did not have a big say. But if you look at the number of constitutional petitions for the pre-95 Constitution, and you compare the post-1995, you'd think that 1995 is the most unclear constitution that Uganda has had. It's a constitution of the people.
Yes.
Now, everybody is wanting space, which is okay. Everybody is asking for space in the constitutional court. You know, I don't want to trivialize anybody's petition, but I'll give you some examples and that call for serious thinking of how adversarial litigation is taking place in Uganda, because we're looking at interpretations. We actually had a petition filed by God.
God?
Yes. Yes, Yahweh.
Or some NGO called God.
No, it was filed by God.
Oh, wow.
Someone brought it on behalf of God.
Oh, interesting.
And we were saying the God of was being diversionary. The God of the Muslims is not the same as the God of the Christians. They wanted a constitutional interpretation on that one. You know, and so we fixed it, you know, out of abundance of humor. Sometimes we need it. And we wanted to see the petitioner show up. Unfortunately, this is not good for my personal salvation. God didn't show up, and we had to dismiss.
Oh, wow.
We had to dismiss his petition. So,
very interesting.
Yes, but we all know that at the back of it there is somebody who has done that. When you reach now, the new approach is when you reach the end of your adversarial litigation, then you come to the Constitutional Court under Article 44, right to a fair hearing. That you see, the whole system was rigged.
Was biased.
I think very soon we're going to have these changes taking place. Yeah. This is not sustainable.
It's not.
It's not sustainable. And so we're going to see these changes taking place. So yes, the answer to your question is we can't keep on doing things the old way. So the new way has to come.
Yes.
And as the switch takes place, and you have practitioners like yourselves who say that we're interested in that space that is untapped and are willing to nurture it, I think that is a space that is going to grow. Because they're also, it's not to say that even African traditional justice systems are perfect. There are imperfections there. There are cultural biases which are embedded there. There are power issues that are also embedded there that have to be leveled out in terms of the playing field. That's where lawyers can play a very important role. The move under 126(2) to substantive justice, which is already incorporated in our constitution, is, I think, the valve that will give us a change. Yeah.
But I'll draw back now to the future. Okay, so now we are moving forward. That door, the multiple door in the public litigation space. In my mind, I'm just trying to paint that picture, and I'm thinking, okay, are we going to have mediators taking up, being empowered to not only just facilitate, but they can be able to have the authority perhaps to even enforce.
Yeah, judgment in vain is really a bad judgment. If someone cannot recognize, someone cannot acknowledge a judgment that has been made, then you must have teeth to enforce it.
Yes.
And this is now the next level of architecture that is going into what people call the ADR space. First of all, I would like people to go back and look at the Arbitration and Conciliation Act of Uganda and look at the part which deals with conciliation.
Yes.
Now, that I think is the model that is coming, because conciliation is private, but the act allows the decision of the conciliator, not of the parties following the conciliation, to be registered as a decree of court. That provision already exists. I'm surprised that people are not doing conciliation because it has been on our books since 2000. This is 2025, 25 years. But I think the architecture is going to start to look like that. And I think there's a lot that is coming with the ADR Act. Some of these questions are going to be absolved. My view is that it will start to look like an enforcement of an arbitration under the New York Convention. That apart from process, you will not be able to challenge it. So if you elect to go private, that's it. You cannot exit. That's what the part on conciliation basically says. It shall be treated as if it was an award under the New York Convention. Internationally, with the recent Singapore Convention for International Mediation, the Singapore Convention has come to life. And more countries are signing up. So the Singapore Convention is going to be equal to the New York, which will allow for portability of international mediations being enforceable in member states. So the architecture of enforcement is starting, the building blocks are starting to fall in place. So if that has been a main disadvantage, then that one is slowly evaporating. And I foresee the reality which has always been there for a long time, that a person should, how the Americans say it, perhaps I'll say it differently, you should stand by your bargain, and the law will enforce it. If you agree that you are going to do something and you have not been coerced, it's not procured by fraud.
Voluntarily.
It is purely voluntary. Then you should be held to it. Your agreement is your bond. You see? So, but that is also in African culture. Ubuntu.
Ubuntu,
yes. Ubuntu mulam. If you say you're going to do something,
do it.
Then it is expected in our societies that you will do it. If you don't do it, then consequences consequences come. I know some cultures, if you promise to take bride price and you forget to do so, but you take the woman, and if God forbids the woman passes on,
they come and take.
They come and collect.
True.
They enforce it at the time of what? Of burial. This is African.
Yes.
This is African philosophy.
Or you pay it.
Yeah, no, of course you pay.
Or you pay. That's the alternative.
Because now your children look at, hey, you want them to take mommy now? I know a private situation where that took place, and I was just absolutely amazed at the memory that people had of this promise of many years before. And some say, hey, sorry, but there's also this one that is pending.
Wow.
It is pending.
So you have been on Mabanja all these
years? Yes. Yeah. I don't know if they have to pay little interest also.
I would think so.
But the point I'm trying to make is that even in African culture, it is, if you make a promise, you need to make good that promise. Otherwise, you'll be ostracized. You may even be excommunicated from that particular group of people. We had our own methods of dealing with that. So it's only logical that process be formalized and be given the force of law.
Fantastic. So as we wrap up, in your experience and speaking to the practitioners out there, the MedArb system, is it just a buzzword or is it a reality? Would it still drive and combine win-win and perhaps with the arbitration, the private litigation of win-lose? How do you see that also being farmed up to give us a greater way of resolving disputes?
Really, MedArb is something practitioners in the area of arbitration should be looking into before, during, and after. Yes. People have the right, the dispute is theirs, people have the right to negotiate a settlement at any point of time within the dispute resolution timeline. And so the people in America have taken the benefits of settlement in adversarial litigation into arbitration. So arbitration may just be a point to start weighing each other and then settle ultimately. So yeah, there is no obligation not to talk at any point in a dispute. You can talk at any time. Yeah.
Fantastic. Thank you so much, my Lord, for having given us the time and really, really debunked the myths that are out there, but also being able to shine a light that we need, not just as practitioners in this space, but your conversation applies to almost everyone. I think everyone. Anyone who is privy to a dispute, and we all are, we know disputes are part of life. Young lawyers practicing, getting into practice, law schools, law development center. I mean, the information is so invaluable. And I also appreciate that you have given us insights into the future. And like the Bible says, those who have ears, because it's not a myth. And as ICAMEK, of course, being one of the facilitators for such environments, I foresee a lot of collaborations happening, a lot of awareness, information, training, to build this capacity, because the public out there, just like you clearly pinpointed out the statistics, where are these 90? I'm going to start looking for the 90%. It's such an alarming number. Where are they, So I think there's quite big opportunity, the space that you have opened, the knowledge you have shared. So thank you so much. We cannot thank you enough for your time and such great wisdom that you have shared. And we hope to have more of you in this space, and look forward to this dispute resolution environment converging for the better of everyone. So thank you so much, my lord.
Thank you for having me.